Hello, everyone. Welcome. Thank you for joining us today. My name is Bianca Collins. I'm the curator of public programs for the Fowler Museum at UCLA. Thank you for joining us today or tonight, depending on where it is you're tuning in from around the world. The Fowler is honored to co-present today's program, Indigenous Knowledge, Aboriginal Artists and Law, with UCLA School of Law's Native Nations Policy and Law Center. This is part of the Fowler Share the Mic series. We at the Fowler believe in the civic duty of museums to give forum to multiple points of view. This series features thought leaders, artists, activists, and allies who are guiding us along the arc of justice. To complement our current exhibition closing this weekend, Aboriginal screen printed textiles from Australia's top end, we've brought together a group of cultural ownership experts in the fields of law, education, copyright, and the art market to discuss the biggest challenges Indigenous Australians face in maintaining control over their intellectual property. A case study shared by 3 Australian panelists will illuminate the work that they do to protect Indigenous art and the ways in which they rely on one another. Their presentations will be followed by a conversation moderated by Lauren van Schilfgaarde, San Manuel Band of Missions Indian Director, Tribal Legal Development Clinic, Native Nations Law and Policy Center at the UCLA School of Law. The speakers will discuss what, if any, cultural knowledge should remain internal and confidential, how the history of Australian-Aboriginal relations impacts the policies in place today, and what immediate and longer-term solutions are being applied to a variety of concerns in this field. Lauren van Schilfgaarde, Coach de Pueblo, supervises live client projects concerned with tribal governance and justice systems, ethics, cultural resources protection, voting, child welfare, and more. She received her undergraduate degree at Colorado College and her law degree from UCLA School of Law. Previously, Van Schilfgaarde served as the tribal law specialist at the Tribal Law and Policy Institute in West Hollywood, California, where she worked with over 80 tribal nations, coordinated training and technical assistance at tribal courts, and focused on tribal healing to wellness courts, restorative justice, tribal court infrastructure, and federal Indian law. Lauren will have the honor of introducing our panelists in just a minute. I just have a few quick technical bits of housekeeping and then we can get going. Once screen sharing begins, I encourage you to click view options at the top of your screen and then select side-by-side mode so the video feed doesn't cover any of the presentation. And if you have any questions during our program, please do submit them through the Q&A function found at the bottom of your Zoom screen. You can submit and upvote entries that you'd like to be considered to be answered at the end of the program. All right, that's all from me. Over to you, Lauren.
Thank you, Bianca. As she mentioned, I'm Lauren van Schilfgaarde. I'm with UCLA's Native Nations Law and Policy Center, and I'm really honored to be here today, in part because I'm really excited for our panelists and I'm really excited for this subject matter. So I am speaking from Tataviam, Tongva, and Chumash lands here in Burbank, California. In the Tribal Legal Development Clinic, we work with tribes within the United States on a variety of matters, including the protection of cultural resources, as well as intellectual property. And it's kind of a mess. There's really not great resources for tribes here. The United Nations Declaration on the Rights of Indigenous People recognizes the right of Native people to maintain, control, protect, and develop their own cultural heritage, as well as their intellectual property. And that's a big deal because most nation state laws don't recognize all of those protections, at least not comprehensively. Here in the US, Indigenous people have been fighting for a long time to protect their cultural well-being. After centuries of battling genocide, termination, forced assimilation, and explicit efforts to exterminate culture, we're experiencing a real renaissance, a revitalization, but it's a struggle. It's ironic that there's a growing market that really seeks after Indigenous art, while there's minimal support for actual Indigenous artists, including protection. This has produced a multitude of tensions. On the one hand, Native people need support, including financially, but also legally. What images and stories can and should be shared? What should remain internal and confidential? For Native art, there's a tradition that usually conceptualizes a lot of cultural heritage as communal. And so is it even capable of participating in an individual-centric property-based market? How do we determine who's Indigenous and who should be protected? On the other hand, there's not just a market, there's a hunger for Native cultural heritage. This has produced sort of a fetishization of Native people, as well as a Black market in which bad actors attempt to access Native art through nefarious means while also falsely purporting to be Native themselves. Under US law, we have some protections. We have the Indian Arts and Crafts Act. We also have the Native American Graves Repatriation Act that seeks to return cultural items to tribes, including those that should never have been on the marketplace to begin with. But due to limited and lackluster enforcement of these laws, there's a lot to be want. That sort of begs the question, what's out there? What should we be looking at? Are there any hopes or guidelines? And for that, I am really, really excited to learn more about what's happening in Australia. My inclination is that there's a lot of common denominators, a lot of common issues, but I think there's also a lot of different issues. Similarly, I think there's a lot of common approaches and a lot of different approaches. I'm really excited to learn about these. And with that, I'd like to introduce our panelists. As I introduce you, I encourage you to turn your video on while I read your bio, and then we'll begin the presentation. Trish Adjei. Trish is Wuthatha and Mabeok Islander and a Ghanaian woman from Sydney, Australia. She holds bachelor degrees in arts and law from UNSW and currently works at the Australia Council for the Arts as the head of First Nations Arts and Culture. Previously, she worked at the Copyright Agency as the Indigenous Engagement Manager, served on the City of Sydney Aboriginal and Torres Strait Islander Advisory Panel, and has been a board member of the Contemporary Pacific Arts Festival and the Mughal Performing Arts Board. As a 2018 Churchill Fellowship recipient, Adjei investigated the practical application of laws protecting Indigenous cultural rights in the US and Panama. Thank you, Trish. Stephanie Parkin. Stephanie belongs to the Quandamooka people of Minjerribah, North Stradbroke Island. In her role at the Copyright Agency, she assists Aboriginal and Torres Strait Islander artists with licensing and resale royalty queries. Parkin is also chairperson of the Indigenous Art Code, a voluntary code of conduct aimed at promoting fair and ethical dealings between art dealers, licensors, and Aboriginal and Torres Strait Islander artists. Both roles have a strong focus on artist advocacy, including the launch of the Fake Art Harms Culture campaign in 2016. Parkin is involved in lobbying for stronger Indigenous cultural and intellectual property protections. Thank you, Stephanie. And finally, last but not least, Robyn Ayres. Robyn has been a lawyer for over 20 years and has served as the CEO of Arts Law Centre of Australia since 2002. She is committed to ensuring that artists and art organizations properly understand their rights as well as their legal responsibilities and are fairly rewarded for the work they do. Prior to joining Arts Law, Ayres spent a significant part of her legal career working to achieve social justice for different groups in the community. She was a lawyer with Royal Commission into Aboriginal Deaths in Custody from 1988 to 1991, a public interest lawyer at the Aboriginal Legal Service WA from 93 to 98, and executive director of the Mental Health Law Centre WA from 98 to 2002. In 2004, under her direction, Arts Law established the Artists in Black Service, which focuses on offering legal advice to Indigenous artists. Oh, I love it. Thank you so much, Robyn. With that, we are going to dive into our presentations. And so I invite Trish to get us started, and I believe we'll be sharing screen for presentation. Thank you.
Great, thank you so much, Lauren. Good afternoon, good morning, everybody. I would like to thank the Fowler Museum for the invitation to present today, but I'd like to start off by acknowledging the traditional owners of the country I'm calling in from. So the Yidinji and Jabbergai people of Cairns in the very north of Australia on the east coast. And I also like to acknowledge any First Nations people who are on this Zoom call as well. So today I'll be talking a bit about, firstly, what the Australia Council for the Arts does in Australia, a bit about our sort of newly published First Nations Arts and Cultural Protocols, as well as some information around some policy work that the Australia Council has been working on in terms of developing a First Nations Arts and Cultural peak body in Australia, and then sort of touch on a bit about the Fake Art Harms Culture campaign back in 2016, as well as some work that's happening at the United Nations level in terms of the World Intellectual Property Organization in Geneva. So next slide, please. So the Australia Council for the Arts, we're the national arts funding and advisory body in Australia, and we provide funding, advice and support to Australian artists, industry and arts organisations across the country. And my role as head of First Nations Arts and Culture is really to make sure that the work that the Australia Council does supports and cherishes First Nations, Australian artists and organisations in the work that they're doing in terms of funding, any sort of policy work, but also if artists are working and organisations are working overseas as well. And in terms of our sort of strategic plan at the moment, our corporate plan, we're also looking at, with our research team, looking at increasing the public value of the arts in Australia and overseas, because we see that the arts and cultural sector has a really great benefit in terms of health and well-being, mental health as well, economic benefits, tourism benefits, as well as education as well. And at the Australia Council, we have a First Nations Arts strategy panel, which is made up of a number of different First Nations arts and cultural leaders from across the country, who again provide us that strategic sort of high-level advice in terms of the different projects that we develop at the Australia Council for First Nations artists in Australia. And so that's a link to our website as well. And I'll just go to the next slide. But back in the early 2000s, so actually in 2002, the former Aboriginal Arts Board worked with Dr. Terry Jenke, who's a leading Indigenous IP lawyer in this space as well, to develop these First Nations protocols. Because in Australia we don't have sort of full protection for Indigenous art and culture, the Aboriginal Arts Board back then decided that it'd be really important to provide these best practice ethical guidelines for people wanting to work and engage and collaborate with First Nations artists and organisations in Australia. So fast forward to 2018, we're up to our third edition of these protocols. They're available on the link on the Australia Council website. It's about a 200-page document, but it's there to really provide that sort of best practice guidance on how different organisations might want to collaborate with Indigenous artists in Australia. So the protocols sort of, the first part goes through a number of the legal issues that we see in Australia in terms of copyright protection, some of the cultural heritage laws, some of the new language laws that we're seeing, and also talking about the United Nations Declaration on the Rights of Indigenous Peoples, the work that's happening at WIPO in Geneva in terms of protection of traditional knowledge and traditional cultural expressions. But the 10 principles that we see in these protocols really talk to Article 31 of the United Nations Declaration on the Rights of Indigenous Peoples. So really implementing that sort of high-level work around how you implement cultural protocol within your practice. And so I won't go sort of through all the principles, but there are 10 principles in there that Dr. Terry Jenke has developed. So looking at sort of respect, self-determination in terms of having First Nations leadership on a project, a really important principle around communication, consultation and consent. So making sure that if you are going to be working with specific Indigenous content or a community, that you have elders' consent from the beginning of the project to the end. Interpretation and cultural integrity and authenticity, that right that the authentic voice should come from Indigenous peoples, not someone that's sort of, studied Indigenous culture for their PhD, for example. If you want that authentic voice, you should be working with elders from the community where that knowledge or where that cultural expression comes from. And then the next 5 principles on the next slide talk to elements around secrecy and confidentiality. So recognizing that, there might be instances where there is secret or sacred men's stories, for example, or women's stories that only particular people from that community can see and hear and practice. And so recognizing that you may not be able to publish or present that secret or sacred cultural expression or knowledge. The next 2 principles are really important around sort of attribution, which is, sort of hasn't happened a lot in the past, but making sure that if you are working with a particular community, for example, you Dingi people, that you acknowledge and attribute that cultural knowledge, that story, that music, that artwork, that design comes from the Dingi people. And then in terms of any sort of commercial returns or benefits going to a particular community, making sure that there's benefit sharing addressed in any sort of agreement that you might have, and making sure that you pay the elders or cultural custodians for their time and expertise and knowledge in terms of working on that project. And then the last 2 principles talk around sort of continuing cultures, that Indigenous culture in Australia is always evolving. It's never static. There are people living in remote areas, in regional areas, in the cities as well, and recognizing that there are over 250 different language groups in Australia that are very different from each other. And then just lastly, in terms of recognition and protection, that there is still that desire to have Indigenous cultural IP recognised within any sort of new laws that might be developed, but also, for example, the arts law sample agreements on their website have Indigenous cultural IP clauses within those agreements. So making sure that you implement these protocols within any sort of agreements, licensing agreements, for example. And then moving on to the next slide. So the second part of the protocols talk to the different case studies that we funded Australia Council, so the different art forms we funded Australia Council, and this is really the practical application of those 10 principles of the protocols. So Dr. Terry Jenke and her team worked with a number of different artists and organisations to implement those 10 principles within these case studies, so that you can see how those 10 principles play out in real life. The next slide, I'm sort of running a bit out of time. Next slide, please. But I thought I'd just also briefly mention some of the work that's been happening at Australia Council sort of for the last 10 years. There's been a number of calls again for a National Indigenous Arts and Cultural Authority, or peak body, that would represent and support and advocate for the First Nations arts and cultural sector. And so that's some of the work that we've been doing. And then in October this year in Adelaide, in the south of Australia, we will be holding a summit, Parumpa, which will discuss sort of the next steps of this work and also celebrate 50 years of the Australia Council Aboriginal Arts Board as well. Next slide. I'll leave Steph to talk about the Fake Art Harms Culture campaign because I'm running out of time, but just to say that the Australia Council did provide a submission to the Productivity Commission last year into the inquiry, the sort of economic inquiry into the Indigenous visual arts market and the effect of selling inauthentic Aboriginal and Torres Strait Islander art on the market. And we're due to sort of hear the findings of the Productivity Commission sort of inquiry and their recommendations later this year. And then last slide is really sort of bringing it to that international level. So I've been fortunate enough to work with the World Intellectual Property Organization in Geneva. I worked there in 2010 as their Indigenous IP Law Fellow, but really the work that's happening at that international level to draft new laws to better protect traditional knowledge and cultural expression, and also genetic resources, is an ongoing discussion. I'll be going to the meeting in September this year, and it's really sort of good to see that this work is still happening and that countries are still involved in this discussion. But I'll leave it there. Thank you very much for your time. I'll now hand over to Steph Parkin, who is at the Copyright Agency and the chair of the Indigenous Art Code. Thank you.
Thank you, Trish. And I'd also like to extend many thanks to the Fowler Museum and the organisers for extending the invitation for the Copyright Agency to be present and share information with you all today. I would like to acknowledge the traditional owners of the land upon which I'm dialing in from today, and that is the Yagara and Turrbal people of Meanjin, also known as Brisbane, in the state of Queensland. So we're on the east coast of Australia right now. So I'd like to pay my respects to the traditional owners. And as mentioned in the introduction, I belong to the Quandamurka people of North Stradbroke Island. So we are saltwater people, and our country is also located on the east coast of Brisbane, not too far from where I am today. Hello to you all. It's great to be able to be here today. And I'd also like to acknowledge all of the people who are dialing in and extend my respects to Indigenous peoples and the lands upon which you are also on today as well. I wear a few different hats in the space that we're working on, but today I'm here talking in my role at the Copyright Agency. So the Copyright Agency is a non-for-profit organisation. The main office is based in Sydney, but we have a national reach supporting not only Aboriginal and Torres Strait Islander artists, but a whole range of artists across the country, authors, writers and publishers. So a broad reach of representing creatives in different spaces. My role at the Copyright Agency, and really the visual arts team role, is focused on supporting non-Indigenous artists, but particularly my role, supporting Aboriginal and Torres Strait Islander artists to assist in understanding their rights and to assist with the licensing process. So as Lauren said, there definitely is a thirst for people to engage with and understand Aboriginal and Torres Strait Islander art and culture. So we do see a lot of those requests come through, people wanting to engage with Aboriginal and Torres Strait Islander artists or art centres. And so our role, the main role that I'll be talking about today, giving some examples of, is the work that we do in assisting in the preparation and negotiating of licence agreements. So I'll just run through a few different examples of the work that we do. I will then touch on the work to do with the Fake Art Harms Culture campaign and information on the parliamentary inquiry that occurred. So at the Copyright Agency, the process of licensing, we really are focused on the voice of the artist, so representing the artist's rights. The process is about reproduction of the works and really making sure that the artist's voice, the artist's rights, the artist's Indigenous cultural and intellectual property rights are centred along the whole licensing and reproduction process. So our visual arts team, and you can find more information on how the team works and the type of work that we do on our website as well, copyright.com.au. So just on this slide here, you'll see just a sort of visual example of the original artwork. We work the artist through the design stage and then the final product. Understanding of payment fees and permitted use. Next slide, please. So the next few slides I'll go through as examples of work. So these are some original works by artists in Western Australia. These were artists by the name of Kitty and Guru. So on the left-hand side, it's a representation of spring dry riverbeds. And on the right-hand side, beautiful yellow sugar bag and bees representing bush tucker. Next slide, please. So those were the original works, and this is the example of how the project worked together and reproducing the works in Perth Airport in terminals. So we do see a lot of these types of requests come through, and making sure that the artists are key and at the centre of these negotiations. Next slide, please. This was another collaboration that we worked on. So this was a fashion collaboration between Gorman and Mankadja Art Centre. On the previous slide, you saw the original works, and then on this slide here, the reproduction of those works into beautiful garments. Next slide. Something that some more of you might be more familiar with. This was beautiful works by the late artist Emily Kingwari, so working with the estate on the reproduction of Yam Dreaming onto the Qantas Dreamliner. Next slide, please. And again, just an example of how that ended up and what it looked like. And again, making sure that the artist's estate and family members were approving and were comfortable with the end result. Next slide, please. We are seeing a lot of homewares collaboration at the moment. So these are some beautiful works from artists up at the Barbara Women's Centre, which is at the north of the Northern Territory. These are some beautiful works. And on the next slide, you'll see how those works were then reproduced onto these beautiful homeware collections by Kip & Co. I think what's important to note here is these type of collaborations, when they're done properly, when artists are engaged properly and they understand all of the arrangements and how the works are going to be reproduced, these things can take time, but it's all about making sure that things are done properly. Next slide. I'll just skip over the resale royalty scheme. It's something that we work on, but I'll just keep going just for time's sake. So fake art harms culture. Next slide, please. That has been existing in Australia for quite some time. It's still existing now, despite all of the things that have happened over the last few years. And it's probably not too dissimilar from things that are going on with Indigenous peoples all across the globe. So the problem that we have here now is Aboriginal style art and craft products that are made by non-Indigenous people, usually made overseas. They're imported into Australia by non-Indigenous businesses and then sold all across Australia through different retailers for profit. And these are products that are made without the consent or involvement of Aboriginal or Torres Strait Islander people at all, even though they clearly look like they're made by an Aboriginal or Torres Strait Islander person. Next slide. So again, these are just some examples that of that type of product that were collected as part of the Fake Art Harms Culture campaign and really used to identify the problems that do exist. Next slide. So the Fake Art Harms Culture campaign, there's been a lot more actions that existed in relation to this campaign and the work that's been done, but I've just named a few here. So the Fake Art Harms Culture campaign really came about because artists were approaching our organisations, becoming very aware of the fact that there was these fake products that were saturating the market. You'll see them in the shopping centres, at airport shops, everywhere that you would go, usually aimed at the souvenir market, so the lower price point of works. So our organisations got together to launch the Fake Art Harms Culture campaign. And really the campaign was about making it aware that this problem exists. The problem being products that have the look and feel of being made by an Aboriginal person, but are not made by an Aboriginal person at all. And out of that campaign and other steps, there was a parliamentary inquiry in 2017 that looked at this specific issue of fake Aboriginal art and craft products in the market. There was a range of different submissions that were put forward, public hearings, that the committee members went around to Australia to hear directly from Aboriginal and Torres Strait Islander people on the issue, and it raised a whole range of other issues as well. Next slide. I think what's really important to note that as part of the inquiry process and the issues that were discussed, Aboriginal and Torres Strait Islander people spoke very strongly about the impacts of fake art and how it impacts not only in a financial sense, but the health and well-being of our people. It impacts the cultural aspects of the work, and you can see some of the words here that were used by Aboriginal people to say how they felt that their culture was exploited, demeaned, destroyed and disregarded by the existence of fake art, and that it is a major problem. From a financial point of view, it removes the ability for artists to earn income, which is also a very important source of income for people. It also had impact on creativity, reducing consumer confidence, and really importantly, which I think what Lauren touched on as well at the beginning, the impact that it has on our national identity as Australians more broadly, and how it reinforces the coloniser relationship by allowing that exploitation to continue. Next slide, please. These are some of the explanations that Aboriginal and Torres Strait Islander people provided as part of the inquiry to talk about the importance of being able to create work. It's not just the physical piece, it's not just the aesthetic of the physical piece of work, it's all of the stories and knowledge that influence the work that give it its value and give it its purpose and meaning. So those are some of the quotes there. Everything that goes into an artifact or painting is a part of us. It's a part of our culture and it's a part of our language. So our people speak very strongly about that. And on this side here, these were some of, again, some of the negative impacts that our people were talking about when they see fake art and continue to see fake art on our shelves. It really hurts, it stings for me, and it makes me feel ashamed and disgusted that Indigenous designs are stolen. So our people have been very vocal about this issue and have been vocal about the legal mechanisms and law reform that needs to happen in order to make sure that this product has no place in our society. So what I will do now is hand over to Robyn to talk more about the legal aspects of this issue.
Thanks so much, Stephanie. And I would also like to start by thanking the Fowler Museum and also acknowledging the traditional owners of the Camaragal people of the Eora Nation, where I am situated in Sydney today, and pay my respects to the elders past, present and emerging. If we can flick through to a couple of slides. So who are Arts Law? So Arts Law is the National Community Legal Centre for the Arts. We are a not-for-profit organisation, and we're the only community legal centre in Australia providing this assistance to artists and arts organisations. We assist artists right across the country, and we provide advice across all art forms. So visual artists, music, writing, performance, dance, designers. So as long as there's a nexus between the artist and the art form, then hopefully we will be able to assist the artist. If we can just move to the next slide, please. And the one after, we are all about empowering artists and creative communities through the law and strengthening value and respect for arts and culture and creative communities to make a better world. Arts Law has, if we can go to the next slide, please. We provide artists with free telephone legal advice. So that's right across the country and for a really broad range of artists. We assist about a couple of thousand of artists each year. So free telephone legal advice. And then we also have a document review service. We've developed a suite of information sheets and sample agreements to assist artists and the broader community understand the legal issues affecting artists and put in place best practice. So Trish referenced some of our contracts, which we aim to be fair and best practice so that in any deal, they're fair to the artists. We also provide a wide range of workshops and seminars, webinars, podcasts each year. And importantly, we also do advocacy for artists and arts organisations on the legal issues which affect them. So we're an artist-first organisation, putting the position of the artist first and foremost, so that any advocacy we do is about, what better protection is needed for artists, or is this going to, are these proposed amendments to a law going to have a negative impact on artists' rights? So that's the way we approach our advocacy work, law reform, policy reform work. Next slide, please. Artists in the Black is the service that we developed in 2004, and it was designed specifically for Aboriginal and Torres Strait Islander artists, and responds to the legal issues that artists and their arts organisations come to Arts Law for help with. We have a Artists in the Black coordinator, that's a designated role, and we're continuing to build the Aboriginal and Torres Strait Islander team at Arts Law. We have 2 Aboriginal board positions, and we have an Artists in Black committee of the board. The service is free for all Indigenous artists in Australia. It's a free subscription because we want to ensure there is really good access to the service, so people understand what their rights are and are empowered to do something about them. Next slide, please. We also provide a supplement, the telephone advice service, by doing a lot of outreach. So Australia is a big country, and there are a lot of Aboriginal artists spread across the country, a lot of Aboriginal owned art centres. And we found that it's most effective if we can go and actually meet with people face to face. So we have a very active program of outreach, obviously affected last 2 years by COVID. And one of the things that we were a little bit surprised about years ago was a number of artists that wanted us to help them put wills in place to make sure their art and their estates, their copyright, are managed properly after they pass away. So we have a big wills program. We've also got an Adopt a Lawyer program, which is empowering art centres, Aboriginal-owned art centres, to have a one-on-one relationship with a law firm, often large multinational law firms, and they have that relationship in place for 3 years. So that they have a direct relationship. And we've got 12 of those partnerships set up across the country, often helping art centres with governance issues and all the other legal issues arising. So if we go to the next slide, please. One of our projects is licensing the right way. As Steph has pointed out, the Fake Art Harms Culture campaign really raised there are a lot of issues around licensing, and a lot of problems that artists are having with licensing deals. So they can, through this project, get advice, legal advice from Arts Law about licensing issues, contract reviews, and pro bono referrals. We also have been working in collaboration with the Darwin Art Fair, who has an Indigenous fashion project, to develop resources to help people who are involved in these fashion collaborations, who want to work with Aboriginal artists, or Aboriginal designers who might want to work with Aboriginal artists, to put in place best practice. Next slide, please. So getting down to the nitty-gritty. So in Australia, what laws are there protecting Indigenous culture and intellectual property? We've heard about some of the problems that we have, and that was the reason why we're responding to those problems with the Fake Art Harms Culture campaign. But there are some laws, but there's nothing comprehensive. So we have our intellectual property laws, which are very similar to the intellectual property laws of other countries right across the world. Our copyright laws, moral rights, trademarks, designs, and other. So if we're looking at other areas of Indigenous culture and intellectual property, there are also the Patents Act, and there are So there are there are laws in place, but they don't protect all aspects of ICIP. We have in Australia native title and Aboriginal heritage laws. They protect land and sacred sites. There's one state that has some ICIP protection in their Aboriginal Heritage Amendment Act, that's Victoria, but you have to register the ICIP in order to get any sort of protection under that, that law. There's also both national and state consumer laws. So there's the Australian consumer law, and each state and territory has laws dealing with misleading and deceptive conduct. And also we've got criminal laws if something is being sold as fake and it's not all, something's being sold as authentic artwork and it's fake, then someone can be prosecuted under the criminal law. But there are big gaps in protection available. Next slide, please. So as part of the Fake Art Harms Culture campaign, we recommended, and together with the Copyright Agency and the Indigenous Art Code, we've worked together on this campaign, recommending that we get an amendment to the Australian consumer law to create a new offence for those engaging in the trade of Aboriginal style art products that have got no connection to First Nations artists or communities, so that that would then become illegal. And as a result, we've actually seen 2 bills introduced into Parliament by minor parties, but they haven't been passed. We're also calling for better regulation of the Aboriginal and Torres Strait Islander art market, both looking at whether or not a mandatory code is needed, but also that there should be fair licensing, should be provisions for fair licensing contracts for Aboriginal artists. And last but not least, and most importantly, is strong laws to provide a layer of recognition and protection for Indigenous culture and intellectual property. And I'll finish now, but just provide you with a slide showing you where you can get some resources from Arts Law. And I think we're going to all come back together.
Thank you, Robyn. Thank you to all of our panelists. That was fascinating. It sounds like Australia is doing a lot to address this issue, recognize it's an issue, and attempt to implement some remedies. I wonder if this may or may not be answerable from our panelists, but to what extent are Aboriginal communities participating in these efforts and contributing their own expectations for how their culture can and should be handled? Or is this predominantly an interaction between the state of Australia and individual artists?
Right off here, Trish and Robyn, feel free to jump in as well. I think Aboriginal and Torres Strait Islander people here in Australia have been talking about this issue directly to organisations and government for a long time, you know, from the 60s onwards. So there's been very strong speaking up and talking about the need for better protections for artists' rights and for cultural rights. And that has been made directly to government. We've had a series of different reports and inquiries and research done over, you know, decades of time. So I think from that point of view, Aboriginal and Torres Strait Islander people have been very vocal about these things and has been made known. And I think more recently as well, with the Fake Art Harms Culture campaign and bringing the broader awareness of these issues to non-Indigenous people, when non-Indigenous people hear about these issues as well, they're on board because they say, well, it's like a no-brainer, really, because they also believe that fake art shouldn't exist here as well. So I think there's always been a strong voice from our people and also from the broader public as well, directly to government and also via our organisations that all of us all work with.
Thank you. Trish, those protocols are really exciting. I have my own plans for how they may be useful. I wonder if you could talk a little bit about the extent to which the protocols have been implemented or domesticated in any law, and what work you see looking forward to ensure that this these aspirations become the common denominator that we all operate by?
Yeah, great question. So I think at the moment, the protocols are really there as sort of the best practice guidelines. So we haven't sort of seen them yet implemented into any sort of federal law. Organizations and artists do implement the protocols within their agreements. So as I mentioned, the arts law agreements have ICIP clauses within them, and there have been examples. So some of the case studies that we have in the protocols where they have been implemented within a project and sort of used to really establish the clauses within agreements between artists and organizations. But I think the protocols are really sort of being used by the arts sector at the moment. So we spend a lot of time with a lot of non-Indigenous organizations who are wanting to collaborate with First Nations artists and communities. They do use the protocols within their projects. Also at the international level, the Canadian Visual Arts Advocacy body, CARFAC, they have used these protocols as a base for developing their own First Nations, Inuit and Métis protocols in Canada, in Turtle Island. But again, it's a sort of ongoing discussion that we're having with the federal government in terms of addressing these issues in terms of a new sort of law. We do have a new federal government at the moment, and our Minister, Honourable Tony Burke, will be doing national consultations with the arts sector in Australia in terms of developing a new national cultural policy. And the first pillar of that cultural policy does look at addressing issues that are relevant to First Nations artists and communities in Australia. And so we are hopeful that there could be some change in this space in terms of better protection for Indigenous cultural IP in Australia.
Thank you. And I'd also like to acknowledge all of our audience members. I see questions popping up in the Q&A box, and I encourage you to submit more. Robyn, we've had a couple of questions peppered out that I think go to you. You like deftly overviewed copyright and patent law in like 4 minutes, but I wonder if you could touch a little bit more about how those are effective or not effective within Australia, and what you think. You mentioned a little bit about some legislation that you're supporting. You know, what else would really help to reinforce all of the legal service work that you're involved with?
Well, that's quite a lot, but with the I suppose we don't do very much work in the patents area, but if I look more at the copyright, because we're focused on arts and culture rather than inventions, which is much more what patents are about. But if you look at the copyright laws, it's very much about the way, the appearance of a product, or it has to, and it also that it has to be recorded in some fashion. So whether it's written down or painted or captured on film, and so much of the culture and knowledge that of Aboriginal and Torres Strait Islander people in this country, you don't actually get protection for that knowledge and the stories that are embodied in the work. So all you're getting protection of is the way it looks, rather than those stories and knowledge that are embodied. And so there's nothing providing that protection. And that's what can be really hurtful and harmful, is when somebody's work, that information, that knowledge, that story is taken without permission and used in some way which would be culturally harmful. The other big problem, of course, is that the copyright laws only last, the protection is only the life of the creator plus 70 years. And we're talking about cultures which are, 60,000 years old in this country, and there's been, unbroken tradition. So it's just ridiculous, really. And so someone can just take something that is, say, from ancient rock art and use it without any permission or any sort of thought to the hurt or the danger of using that work without a permission. In terms of the legal avenues to address or the ways that some of these problems can be addressed, I think overwhelmingly there's this need for better laws dealing with ICIP, all those aspects of knowledge and culture that aren't protected. And it's not just in the arts and culture, it's also things like knowledge about plants and remedies and medicines and all those things as well. And then there's the work that we've been doing on this, just that souvenir market. It's just the very tip of the iceberg, really, of all the issues. It's an easy first step that could be taken. And the other problem is with the international situation. So one of the problems that we find with the artists that come to us is that their work is popping up on international websites where there are online infringements. It's very difficult to do something about that. So that's why I think the work that's being done at WIPO and that getting an international layer of protection, a treaty that deals with this would be wonderful, because it means that Indigenous people right across the world would get some protection if the countries adopted those treaties.
Thank you. We have a lot of great questions, and so panelists, feel free to chime in if there's any issues that you would like to uplift. Let's see. One, we didn't have a chance to get into the presentation. So I wonder if any of the panelists would like to briefly mention the resale royalties issue and comment on that.
Yes, I can speak to that. So thanks for the question that's come through around that. So just wanting an update or to hear how that went. So resale royalty legislation was introduced here in Australia in 2010. So we've had, just on a decade now of resale royalty being implemented here in Australia. So the Copyright Agency has been appointed by government to assist in managing the resale royalty scheme. And basically what that requires us to is to assist in monitoring resales, collect resale royalty money on resales, and then distribute that resale royalty money to artists. So the whole premise of the resale royalty legislation being introduced was to ensure that artists have some income on the secondary sales of their artwork, and each time it's resold in the market, if particular criteria is met in the legislation. One of the criteria being that the works have to be sold for more than $1,000. So the resale royalty scheme is existing, and it is being operated by and royalties collected by the Copyright Agency and distribution of those royalties. So it does exist. There's also been some further work done on reciprocity as well with international bodies to ensure that if there are resale occurring overseas, that those resales are also feeding back into the Australian market as well. So there has been a movement on that reciprocity at an international level as well, which we'll be following closely.
Thank you. It's so striking to me. At least one significant difference is the extent to which Australia celebrates and affiliates itself with Indigenous art and really identifies the national identity with Aboriginal art in a way that the United States just hasn't quite gotten there yet. And so like seeing the airplanes and like the promotion of Indigenous art is so amazing. This hour has flown by. We have just a few minutes. And so I'd like to invite each of the panelists in just a minute or two, give us your closing thoughts. I apologize, we weren't able to get to all of the questions. However, I would like to remind the audience that this is being recorded, and we'll also be sharing the PowerPoint slides, which had really great information on that. Trish.
Just really thank you, Lauren and the Fowler Museum for the invitation today to be on this amazing panel. It's great to see all the good questions coming in as well. If you want any sort of more information, feel free to contact me at the Australia Council. But I hope that, you know, these discussions can continue at the international level, and I'd also encourage people to have a look at the work that is happening at the World Intellectual Property Organization in Geneva as well. So really thank you again for inviting me. Thanks.
Thank you, Stephanie.
Thank you, and thanks everyone for your questions, and again for the invitation. These are very important issues that affect all of our communities across Australia, and no doubt Indigenous peoples across the world. You know, these are issues of exploitation that are deeply rooted in fields of colonialism and exploitation of people and of country, of culture, and land and waters. So while we do, from my point of view, while I work in this space, working with Aboriginal and Torres Strait Islander artists and the protection of rights in that aspect, these things are connected, and they're connected in the way in which Indigenous people have recognition and rights in their own country. So I think if we talk about these issues, we also need to talk about truth-telling and understanding the true history of the places of which we all live and work on, and understanding why these problems do exist. There's a reason they exist, and it's getting to the root of those causes, so we can move forward and have better protection and recognition for all of those rights. So thanks again. And look, we've got the Olympics in Brisbane coming up in 2032. So we know there's going to be even more increased pressure on artists to be involved and performers to be involved in the cultural aspects of the Olympics. So the work that we're doing is only going to increase in the importance. So thank you. And yeah, thanks very much.
Thank you, Robyn.
Apologies, I was trying to get the unmute. Anyway, yeah, look, I totally endorse what Stephanie was just saying, and we've got to remember this is going on at the same time. Our campaign, this groundswell that we've had the Uluru Statement from the Heart in Australia, which is looking at having a voice to Parliament for the Aboriginal and Torres Strait Islander people of this country. And I think the truth-telling is all part of it. Just going back to the need for stronger ICIP laws, it needs to be comprehensive in the way that we look at what ICIP is. I really would much prefer if it wasn't a registration system, because of the diversity of Indigenous cultures across this country. A registration system just doesn't really make sense. So those rights should arise automatically and not be time limited. You know, the copyright protection, you know, is time limited, but any laws for protecting ICIP shouldn't be time limited. So I'll just end with that. And thanks so much for having me as part of this panel.
Oh, thank you so much. I can't really thank you enough, Lauren, Stephanie, Trish, and Robyn, for taking this journey with me to make this conversation a reality. It's an important conversation, and I'm just so honored that you joined us today to share your important work with us and fill us in a little bit, so that hopefully the US can follow Australia's lead and do more to protect our Indigenous intellectual property. So thanks for inspiring us today and really lighting the way. It's been very, very, very much an honor to have you here today.
Thank you.
And thanks to everyone who joined us. This program's been recorded. It will be available immediately on the Fowlers Facebook, and in a few days it'll be on our Instagram and on the website for you to revisit and share. We hope you'll join us again for our next program. You can find information on the closing slide. And in the meantime, we hope that you'll have a great day or a great evening, depending on where it is you're tuning in from. And we'll see you next time. Thanks for joining us. Bye.